termination of a contract. And let's just start off with the happy one. Uh, both parties do what they're supposed to do in the contract. That's basically tendering of performance. That's sort of the happy ending. Everyone's done what they're supposed to do. It's over. I'm selling my bicycle. You're giving me money. I hand over my bicycle. You hand over the money. The contract is now terminated. That's what we mean by termination of a contract. It's the end point. Most contracts end that way. Parties perform. And that's why our money, for example, is called legal tender, because it's often part of a tender of performance, because sometimes, not all contracts, but many contracts call for at least one party to perform through the tender of legal tender money. So performance, don't worry so much about time of performance. Sometimes in a contract, it'll say specifically it has to be performed on a certain day, and that date is critical. Sometimes they call it time is of the essence. If the contract doesn't say time is of the essence, sometimes the law will give the party some flexibility if it's deemed appropriate. It doesn't go to the heart of the contract if the parties can't comply within a short period of time. The court will often put in some flexibility. Most people, if they're smart, if they're the ones worrying about making sure it gets done by that date certain, be sure to put in, contract must be completed by August 1st and time is of the essence. That way, if the other party breaches, they can't say, well, we had some flexibility here. I could do it the next day or the day after. But you put in that time was of the essence. That suggests that's the essential part of the basis of the bargain, and therefore you can seek damages if the other party doesn't perform on time. Generally speaking, sometimes we don't always put in when the time of performance is. You hire someone to do the landscaping at your house or paint your house. Sometimes the parties fail to put in a specific date for when performance has to occur. Under those circumstances, we deem it a reasonable period of time. Now, does that get subject to a lot of disputes and litigation? Sure, because what's reasonable to me might not be reasonable to you. But we try to look at what the reasonable person standard is by amalgamation of all of us, what would be deemed appropriate under the circumstance. So time of performance goes in your book. Tender performance is doing what you're supposed to do. Tender of payment, I'm not going to test you on some of this, I don't want to call it trickery, but nuanced issues that technically, if you're required to pay $500, the only thing that will satisfy that tender performance is $500 in legal tender U.S. currency. You can't do it in gold script, or you can't do it in a check technically. But because of business practices over time, the UCC is, that's the Uniform Commercial Code, has recognized that most business transactions, or even just general contracting transactions, often will accept a check as payment, but technically supposed to be legal tender, supposed to be cash. Satisfactory performance. I did want to spend a minute or two on this. Think about it. You're having a house built, and there's many details that go into the building of a home. Now, what if the contractor built the home and they did really a pretty decent job on every single thing, but the one thing they failed to do was put up a wainscoting ceiling on the back porch? It's really 98%, 99% done in terms of the contract. And say the contract was for $300,000 to build this really nice house on your property. Does that mean you don't pay the $300,000 because they failed to do that last part? They clearly are in breach. They didn't put up that wainscoting ceiling on that back porch. However, there's a concept called substantial performance. If the contract's so nearly complete that the heart and soul of their obligation is performed, you do have to pay them the contract price minus that amount of money which would cost to finish the outstanding part of the obligation. And the book does explain it pretty well. This comes up in many areas, not just contract law, this concept of substantial performance. I think about people on probation that I represent. They often have certain obligations to do certain things, and I often argue to the court, if they do the bulk of them, the great significant portion of them, that no violation should be deemed found because they are in substantial compliance. I think you get the drift of what it is. In most contracts, some party can often say, well, there's one detail that's not really completed. But if the heart and soul of the detail of the contract's completed, you do have to pay the contract price, or they have to pay it to you, depending on which end of the contract you're on. But they do get to seek reduction to the amount of shortcomings that came about. Now, what if there wasn't substantial performance? They only did half of it. Well, then they're only entitled to unjust enrichment. They're not entitled to the contract at all because they're in breach. It's a full breach. It's a nuanced area, and what exactly is substantial compliance is a debatable question. But the definition in the book is pretty, I think, pretty solid. It says basically just how far a contractor proceeds. It's about contracts. It's not only about contracting, but it's the nature of it that such that any reasonable observer would say they've completed the essential portions of the contract, and therefore the contract price should be paid with all the profit and everything else, minus that amount of money that it costs to make you whole to finish the outstanding portion of it. Now, satisfactory performance is interesting. For the most part, we have an objective standard, meaning that you do a job for me, you're supposed to, I don't know, paint my house. And I look at it, and I'm just not satisfied. I think I see shadows. I think I see some lap lines, things like that. Maybe I call them snots when you catch an edge and it pulls down some paint, it drips off a little bit. And I'm unsatisfied. Do I still have to pay? Well, we have what's called a satisfactory performance standard that's objective. Would a reasonable, prudent painter and people in the industry say that is done satisfactorily? It's called a workmanlike standard. That's sexist now. I think they've changed it to just standard in the industry. Would that be satisfactory? Now, that's kind of a, we kind of look at it with a judgment call. Would the jury suggest that the paint job was, wasn't perfect? You didn't have Rembrandt paint your house. You had a painter paint your house. Are there some minor things that may not live up to your expectations, but a reasonable consumer would be satisfied with the outcome of the job? Common sense. Now, careful. Sometimes people, because they're so confident in either the goods or the services they're selling, will say satisfaction guaranteed. And this comes up in Chapter 19 with warranties. But think about it. What if the person says in their painting contract, the painter puts in their contract, your satisfaction is guaranteed? And what if I come out and I genuinely say, I'm not satisfied. Do I have to pay? No, I do not. Even if the job was done fantastic. And the concept of unjust enrichment doesn't apply here, because unjust enrichment only applies when there's no contract. We have a contract, and the contract is based upon personal satisfaction. I always think I don't know which bag of potato chips it is, but when I was a kid, I think my sister was dissatisfied with a bag of chips once. And my sister, being very litigious, she's not an attorney, but she's litigious anyways. She always remembered on the back of the thing, if you're completely unsatisfied, or if you're not completely satisfied with our product, just send in the wrapper with your receipt and we'll refund your money. And they did. And of course, we consumed all the chips. So the question is, it can't be for purposes of fraud, but if you're genuinely dissatisfied and the other party warrants that your satisfaction has to be completely had, or you have a right to get your money back, it's a very big risk they're taking. I always use the example of a portrait painter. What if the person comes in and says, I'll paint your portrait, Jim? I always think of Kramer. Some of you, I'm dating myself because the show has been on for years, but there's a guy by the name of Kramer in the show, and for some reason his portrait gets painted, and many people actually collect that portrait. You can buy it on Etsy and eBay and all these other places, and people have it in their dens for whatever reason. But this character, Kramer, was a larger-than-life sort of character. Imagine, so I want to do that. I want to have myself painted. I want to put my painting above myself, a mural of me or whatever, above my fireplace. I hire a very well-known painter, and I have a big party, and there's an unveiling party, and the contract said that I must be personally satisfied with the outcome. Let's assume we have an unveiling party. I pull the drape off the portrait at my big party, and everyone's, ooh, wow, it almost looks like a photograph. It so much captures and likes it, and everybody objectively believes it is a fantastic painted portrait of me. But what if I'm personally not satisfied? Well, the contract said personal satisfaction guarantee. I have a right to basically void that contract, not pay for it. Of course, the painter has a right to keep the product, but what's he going to do with a painting of me? There's not a huge demand for that, so it's going to be a loss. That's why I always tell people, be careful when you want to market your services or your goods, and you want to say satisfaction guaranteed. That's a very, very dangerous thing to do. One, either have a great deal of confidence in your product or services, or maybe the individual product or services isn't very expensive, so you don't mind occasionally someone coming back and saying, I'm not satisfied, I'm not paying for it. But what a huge risk, and I don't think people take it all that seriously. I know as an attorney, I don't think I've ever met any attorney that advertised that way. I can only imagine, especially divorce work, which I don't do anymore very much, but I've never met anybody happy coming out of divorce. Everyone thinks they've gotten somehow shortchanged either financially or over the degree of which they have control or custody of their children. Everyone leaves fairly bitter in many divorces, and I can't imagine saying your personal satisfaction guaranteed or you don't have to pay. And I usually think I do a pretty decent job on those cases, and most of my clients come out pretty miserable. I don't want them to point at me and say, hey, I was really unsatisfied how the things came out, so therefore I'm not going to pay. But that's the rule, so be cautious on that one. If you see it in a test question or you just see it in life, you want the other side to do that all day long, right? You want to say, hey, do you mind putting in there that my satisfaction will be personally guaranteed. You can't commit fraud. You're saying later, oh yeah, this person did all this work for me or gave me these products. I'm not going to pay for them now because I'm not personally satisfied. But if you're legitimately, I don't know how we establish that. I guess there's some kind of trial or credibility test in a trial, that if you're truly unsatisfied, of course you can't keep the product. You have to return whatever product you have. But what if they did a service for you? You can't undo a haircut. You can't undo, mowing my lawn. And if it said personal satisfaction guaranteed, the other side is stuck with that loss. Very dangerous contract, but important for marketing for some people, I guess. I already talked about substantial performance. We'll go backwards there. Discharge by operation of law. Nice little area, pretty simple. Surprise to some people. But if you have a contract with somebody else and they owe you services or money and you already paid for them, and they file bankruptcy, and you're a creditor basically because they owe you either money or services, that duty can be discharged in bankruptcy. Most things can be discharged in bankruptcy in terms of legal obligations. There's a few exceptions like student loans that are backed by the government, taxes, child support, restitution for criminal cases. I can't think of them all, but they're, for the most part, most general contract obligations can be discharged in bankruptcy. So it's a real problem. Somebody owes you $20,000 for work you performed, and all of a sudden they come on hard times, and if they're eligible for bankruptcy and they file it, that legal obligation ends. Discharge in bankruptcy. The book does a nice job. The statute of limitations, it's not going to come up that much for business class too much, but it does come up a lot in law. I know it does in my practice. If you have a contractual obligation with somebody and they breach, you have to sue in Massachusetts within 6 years. Don't worry about the specifics of 6 years. It's different in different jurisdictions, and sometimes certain kinds of contracts have different kinds of statute of limitations. But generally speaking, you should know that if you don't state your claim and pursue your action within a certain time frame, the law might bar you from going forward. It's a pretty strict bar. In fact, the acronym for the statute of limitations, SOL, is what we write on our files for certain kinds of cases, and we put the date on there. I usually put dates long before that in my computer. I have like a tickling system that remind me, hey, next year or next 6 months or 3 months, in the week before, the day of, obviously. But we actually write it physically on the outside of the file. SOL means exactly the same thing as statute of limitations. It means you are out of luck and you cannot pursue a claim. There's almost no exception. And might as well treat it as no exceptions to the statute of limitations if you don't pursue your claim in a timely fashion that the law provides, because we don't want stale claims coming forward. We want sort of things to rest and not have to be dug up much later, because it's difficult to gather witnesses and defend a case if it's so stale. And the same in criminal law, there's similar things too. Some things have unlimited statute of limitations, like murder. There's no statute of limitations in Massachusetts. But other crimes, larceny is 7-year statute of limitation. But for business, most things are contractual nature. In Mass, it's 6 years. Some things like workers' comp are 4 years. I don't know them all, nor should you. Just know as a principle that if something has a statute of limitations, it might be a bar to enforcing a contract because too much time has gone by. Alteration of written contract. I like this one because it's kind of interesting. It has to be a material term. Going back to the materiality of an offer and acceptance, same thing. So if you and I wrote up a contract and because of carelessness, I actually did this the other day. I wrote down a date on something, although I scrapped it and wrote a new little thing up, a receipt to somebody. I put 2021. I don't know why I thought it was 2021. I'm getting ahead of myself. Time's going really slow during COVID for me. I don't know about for you, but I was surprised I put the wrong date down. Now, let's assume I put the wrong date down. I'm back at home. We still had a meeting of the minds over essential issues, and we really did mean to have it 2020 of July 8th or 7th or whatever it was. If I corrected basically a typo like that, a Scribner's error, if you want to call it, that will not change the outcome of the contractual obligation. But what if I, for whatever reason, we never negotiated the interest rate on something, and I'm back at home and I said, geez, we were supposed to have an interest rate in here. I'm going to add this little section and I'm going to put in 14% interest to be paid by the other party after a certain date. They didn't agree to it. I just altered the written contract, and it's material. It's significant. The other party now has a couple of options. One, they can enforce the original contract without the alteration or the addition. Two, they could enforce the new contract because it might be something they actually like. They like the terms in it. Maybe there was something flowing back and forth between the two of us. They say, Corman altered it without my consent. I have a right to basically enforce that new agreement if I want to. Basically, it's called ratification, just like when a minor becomes an adult or somebody mentally ill becomes well, they can ratify a contract that was entered into during a period of incapacity or incompetence. With the written the third option the victim has, victim's kind of strong, but you are the victim. Somebody altered a written contract that you were engaging with them, and they changed it. So you have one, the right to enforce it as originally written. Two, enforce it as altered. Or third, treat the contract as unenforceable if it's executory. Just say, I'm not going forward with you. You've altered contract. I'm off the hook. It's over. It's done. Pretty straightforward. It has to be about a material term. It can't be like a lot of people, when they hear my name Corman, I don't know why, but they just assume it's spelled with C. And listen, we're just doing something over the phone, and I wrote a contract and my name was C all the way, and I took all the C's and I altered them to K. That doesn't really alter the material obligations flowing between the party. It's really done for clarity. It's almost implicit that that kind of thing is not going to probably impact the outcome of the contract. I'm surprised, though, how many times people put in some material stuff and they really try to alter it later on. I'm like, what do you think you're doing? And it's never to benefit the other side. It's always to benefit themselves. And I just think the law should flow one way, I guess, or the bargaining should flow one way. That's why it's called bargaining, as you're doing with the other party. That doesn't mean you can't alter the contract with the consent of the other party. Hey, I was looking at this last night. We've got this agreement. Can we add some terms here? Yeah, you can always do that. That's basically a new contract. Nothing wrong with that. As long as there's new consideration, new obligations, or legal positions changing between the party, consideration, you're fine. And if it's goods, you don't even need that. Remember, sale of goods, that's an exception, no consideration. Now, voluntary agreement of the parties. I'm glad the book put it in there. Parties are free just to say, hey, let's just stop where we're at. Neither of us have performed yet. Let's just walk away from the obligation. I don't want to sell you my car anymore. You don't really want to buy it, or you don't care. You don't want to enforce the agreement. You both can walk away. Voluntary agreement. We're a free society. We can always undo a contract by agreement, and that's the voluntary assent. Someone's going to paint my house next month. I don't know, they hit the lottery, or they just don't want to paint anymore, and and I can find another painter, and I kind of like the person, so I can undo the contract with them. We can both undo by voluntary agreement. Don't lose your common sense when you're taking a law class. That obviously is allowed. This one's a little bit more, I guess, kind of fun. Impossibility performance. Some of you may have had this cross your mind at some point, or thinking, well, what happens in the executory stage? I can't sell you my car today. I need to use it for next week until my car is ready that I purchased from the dealership. And so I'm going to deliver my car to you next week, and I'm going to be allowed to use it. And what happens? It gets struck by lightning during this week, and it explodes and gets completely incinerated. You can't now sue me because I can't go forward, because it's impossible for me to go forward outside of any fault of my own. It can't be from fault of my own. That's called destruction of the subject matter. And that comes up a fair amount of times. It's just impossible to go forward during the executory stage. Usually it's about a thing. It could be real estate. A home burns down. It could be about a car. It could be about anything. A bicycle gets stolen, gets lost, gets damaged. The contract now becomes impossible. And it can't be just that it's difficult. It's impossible, though. The next one, new laws making the contract illegal. So next month, you're going to sell me some herbs you grow in your garden, ginseng. I don't even know what herbs are, but something that's legal today when we're contracting, but you're going to deliver them next month when they come to harvest time. They're going to grow. And it turns out ginseng is something that the government doesn't want to have distributed without a prescription, because it has a certain narcotic effect or something like that. Contract becomes illegal during the period of its executory stage. Therefore, it's kind of a form of impossibility performance legally. Therefore, the contract is now null and void. So new laws making it contract illegal. It happens every so often. It happened one time with, I think it was Iraq. The first time we went to war with Iraq, I can remember there were some people in Sturbridge that had a company that had some contracts with them, not for any kind of armament or anything like that. It was some kind of plastics packaging of some kind, I think. And they had a pretty big contract, not with the government of Iraq, but with a company in Iraq. And all contracts were considered null and void for a period of time between any producer of goods in the United States and Iraq, because we were trying to put an economic freeze on them for that period of time. And a company really objecting, saying, well, this has nothing to do with military. It's a civilian use. It didn't matter. It was a new law. The law came into effect to ban it for a period of time. But later on, things, I think, worked itself out. Death or physical incapacity, but it has to be a personal contract. What if I agree to sell you my car? The contract's going to be for next week. We have it all written out, make you happy. It's notarized, all that stuff, a lot of proof. And I'm going to use it, though, for this week. And you're going to pay me next week. So it's executory, both of us. I drop dead after I do this video because I'm exhausted. I die. Can you still enforce that contract? Yeah, you can. You can enforce against my estate because it's not a service contract. It's not something I had to do in terms like representing you as an attorney or paint your house. All I have is a good that I owned. I still own it in the sense that my estate owns it. My estate would be contractually required to go forward with it if you wanted to enforce it. What we're talking about here is death or physical impossibility for service contracts. So you hire me to be a singer. Say I'm a fairly popular singer in the community. You hire me to come to your big shindig, your big August 1st shindig, because maybe COVID, phase 4, 7, I don't know what we do with these phases, but it's lifted. Now you can have a party. You hire me to come and sing. I do some Tony Bennett stuff or Frank Sinatra. I don't know. That's all I can imagine doing poorly. And I get laryngitis. I can't do it. Or I get COVID. I can't do it. I'm too sick to do it. I am absolved of my contractual obligation, and so are you. You don't have to pay me. And if you have paid me, I have to return the money. It's common sense. It's the undoing of a contractual obligation because of physical impossibility or death. Or insanity does the same thing. Act of the other party. This doesn't come up that much, but it's enough to know for the test or just for the class. Sometimes the other party makes it impossible to perform. So you hire me to fix the engine in your car, but you refuse to bring the car into the garage. You won't tell me where the car is. And then you're saying, hey, I had a contract for Corman to fix my motor vehicle. You never did it. What's my defense to the enforceability of that contract? You made it impossible for me to perform for the obligation. It's like hiring someone to paint the interior of some building, but they don't give you access. It doesn't come up that much. It's enough to know about it. Acceptance of the breach. Yeah, of course you can accept the breach. And this is an important tool too. If you know you're going to breach, and it makes it like I know I'm going to be a bad person. Breaching isn't always about being bad. Sometimes you realize you can't comply because of other work obligations or you've overextended yourself for financial limitations. It's always a good idea to let the other side know ahead of time. So say I'm supposed to paint their house on August 15th or before. I know for whatever reason, it ain't going to happen. I'm just too busy with other jobs, kids, I don't know. Don't wait till August 15th. Obviously, I'm not in breach until August 15th rolls around and I haven't done the job. I'm not in breach today on July 7th. But if I know I'm going to be in breach and I contact the other side telling them I won't perform by August 15th, that's called an anticipatory breach. I'm breaching ahead of time. Why do we do that? It's a great idea to do it, I think, morally and ethically, but it's also a great idea to it's called mitigation of damages. Because what can the other side do if they knew I won't be able to paint their house on August 15th or before, and I tell them today? It gives them time to seek another contractor to lessen the potential harm. They might actually find somebody who's got the same reputation, skill of experience, and things like that with the same exact contract price. There's no damages then. They actually might save money. But chances are they might have to pay a little bit more. But the earlier they know about the future breach, the more likely they'll be able to protect their interests. Same with renting. Like I'm supposed to rent the place, say, for example, come September 1st out of Cape Cod. I decided not to take that job at Cape Cod Community College. So I am going to breach on that 1-year lease I have starting on September 1st. If I notify them today, the landlord, they can't just sit on their rights and say, well, I got in a contract. He's in breach. He's going to have to pay whether he comes or not. They have a duty to mitigate. They have to find a new tenant with the best ability they can and use reasonable efforts. They might not find the one willing to pay as much as I did, but as long as good faith they tried to, they find someone that pays a little bit less, my damages get reduced, and the damage to them gets reduced. Everyone is in a better position if you can do an anticipatory breach. So what are the remedies? Sue for damages. The other is rescind the contract. You're the victim. You can just say, I rescind my obligation because you can't perform and you're not willing to perform. And we'll talk about specific performance in a second. But first, sue for damages. Careful on this one. In our jurisdiction, unlike most, generally you can only seek what's called compensatory damages. That's to give you the amount of money you would have had or been able to retain, but for the other side's breach. You're not entitled to a windfall. You're not entitled to like, oh, thank goodness the other breach. I'm going to have more money than I've ever had before because they've done something wrong. So I'll give you the painting example. I hire you to paint my house. It's going to cost $2,500. You can't do it, or you're refusing to do it for whatever reason, not because of physical incapacity. You're just refusing to do it. What do I have the right to do? Well, now I can sue you. Sue you for what? Well, what are my damages? If I can only go out and find another painter that has equal skill and knowledge and skill and experience, all that kind of stuff, and it costs $3,000, I'm out $500. Cost me $500 more to basically fill your shoes. But what if I went out and found another painter without much difficulty in time, for the same exact price. What have I lost? Some little aggravation. You can't quantify aggravation, so you're not going to get any money. You have to have damages for breach of contract. Sometimes there's breach of contracts and no one's really harmed, and that surprises a lot of students. That the other side breached. And I always ask, because I do litigation, I do trial work. Sometimes people want to sue other people, and I'm like, well, I'll hear you out. What do you got a lawsuit? Because, well, the other side was supposed to do this. That's okay. How are you harmed? Like, what do you mean they didn't do what they were supposed to do? Goes, well, how were you harmed? Did you have to hire somebody else? And sometimes they say yes. I said, did it cost you more money? And I'm always shocked when they say, no, I actually saved some money. I said, so why do you think you're entitled to more money then? How are you harmed? You have to have injury. And so that's an important tool. So you sue for damages. Nominal damages is mentioned in the book. I don't get into too much, but sometimes a jury or a judge might find, yeah, you've been harmed, but it's so trivial. They'll give you a token amount of money. I actually had that in a tort case one time. Nominal damages doesn't come up too much, but compensatory damage, that's the heart and soul. Occasionally, this is rare in Massachusetts. It's more prevalent in other jurisdictions. Something called punitive damages. What are punitive damages? Not only do you get the amount of money that it would make you whole, put you in a position you would have been but the other side's wrongdoing, but you get a bit of a windfall designed to punish and deter the defendant's conduct. And it can be measured in part by the defendant's wealth. So if you're suing, say, McDonald's or IBM or Apple, and you get compensatory damages, and they did something fairly heinous in their contractual violations, if punitive damages are allowed, they may really get hit pretty hard to deter that kind of conduct with future contracting parties. Again, does not come up in Massachusetts very much. It comes up in medical malpractice cases sometimes, which is not contractual so much. It came up in an R.J. Reynolds case not that long ago, in a tobacco case. Somebody smoked cigarettes, and back in the, I don't know what it was, 50s or 60s, they were giving out free cigarettes to young people in certain communities to, basically get them hooked on cigarettes, and then they'd want to buy them afterwards. Initially, they were giving them out free. And this is before they warned people, and there was common knowledge, I guess, about cigarette health issues. This person died, but their estate sued R.J. Reynolds. They got something like, I don't know, $10 million in compensatory damage. The value of the loss of their life early, the jury determined was $10 million, but they gave punitive damages against the tobacco company of, I don't know, like $100 million to punish the wrongfulness of their conduct. Doesn't come up very much. Where it does come up in contract law in Massachusetts is landlord-tenant. Like, landlords are supposed to keep your security deposit in a certain kind of trust fund, and if you don't, the landlord has to pay 3 times the amount of money that was supposed to be kept in the security fund. That's a form of punitive damages. The consumer protection law in Massachusetts has something called tribal damages for unreasonable acts and practices in business. That can sometimes make the damages, compensatory, then times 3. So it's available sometimes. I don't want to make it sound like it's never available, but it's not that often. Liquidated damages, what that means is we actually put in the contract what the other party will pay if they breach, or if I breach. Both parties will have a specific clause paying it. The law doesn't like that too much unless it represents in the ballpark of what you're actually harmed by. Because if it's a windfall for one party or another, the law doesn't like that. The law wants you to only be made whole and nothing really more. So sometimes in real estate contracts, you put down 5% deposit. So say I'm buying a piece of real estate for $100,000, I put down $5,000 deposit. I failed to go forward. We often put in the contract that the seller's damages will be to retain the deposit given. Sometimes that's appropriate. $5,000 on that contract might be very appropriate. They got to relist it. They have to pay real estate taxes again during the period of time to put it back on the market. However, and sometimes on very big contracts, liquidated damages could be a huge amount of depository retention that the other side really gets a windfall, and they may have ease selling it to somebody else later on. So liquidated damages are a bit disfavored. It has to come in within a reasonable amount of money that would justice really seems to be satisfied for both parties. Now, specific performance, pretty rare. This is not for services. You hire me to be an attorney. I have a reputation in criminal defense. Say, for example, you really want me to represent you. I hit the lottery. I'm done with that stuff. I don't need the headaches. I'm moving to Martha's Vineyard, and show's over. I'm returning your money. They say, oh, no, I don't want my money back. I'm going to sue you to make you perform because we have a contract. You can't do that. That's banned by the 13th Amendment to the United States Constitution, the same amendment that bans slavery in this country also banned indentured servitude. Of course, I have to give them money back, but you can't force me to do a service. We just don't live in that kind of society. Thank goodness. And that troubles some people. Some people say, I hired this specific person and I want them to do the job. You can't get specific performance for a service contract. You can for unique items that no two are alike. So it does apply in real estate. No two pieces of real estate are identical. You agree to sell me your farm. I have a contract with you. We write out the terms. And for whatever reason, at the last minute, you decide not to go forward. I can sue you for monetary damages, or I could sue you for specific performance. I could make you confer title to that real estate because the argument is there's no two pieces of real estate alike. It's my option, though, as the victim, I call them victims, but as the non-breaching party, I can either sue for money, what I've lost financially, but in that case, I don't really lost anything because I was buying the real estate, or I could force you to go forward and sell me that property. Specific performance also relates to things like unique artwork. There's just no two alike. I have a real Monet painting, for example, you're selling me for, I don't know, $10 million. You refuse to go forward. I could sue you for monetary damages if I can prove I've lost money somewhere because maybe I was going to resell it and already had a contract for a higher price. Or I could sue to force you to sell it to me. You know, signed autograph things, baseball card collection, coins, things that are unique and not replaceable with a substitute of a like kind because of the uniqueness of their nature are subject to specific performance remedies. Malpractice, I don't know why it's in this section of the chapter. All malpractice is basically you can sue or you can basically alleviate your obligation to contract if a professional, lawyers, doctors, accountants, psychiatrists, I don't know what all the professions technically fall under, but they have to meet the standard of what a reasonable, prudent doctor or lawyer would do in a like circumstance. Not perfection, because on hindsight, everything can say you should have done this differently, but would a reasonable, prudent attorney or doctor have done the same things under the same circumstances? You have a lawsuit, and you can sue for damages if you have been, well, talk better way, shortchanged on the services provided by the other side. It seems like an odd place to put it in the book, but it's there. Obviously, it can terminate the contract. If the other side commits malpractice, you have a right to claim this contract is now terminated. You're committing malpractice, and then you can sue for damages. I'll leave you there. Went a bit long. I apologize. I'm going to post it right now, and I'll be grading homework probably throughout the day. So be well.